What is the Fair Debt Collection Practices Act? The Fair Debt Collection Practices Act, or Fdcpa, is a federal statute that regulates debt collection practices. Importantly, the Fair Debt Collection Practices Act regulates primarily debt collectors. What does that mean? If I take out a credit card and I charge $100 on my credit card, and the credit card company bills me for the $100, they are not a debt collector. They are an original creditor. Now, if I'm delinquent on that $100 and my credit card company passes it off to ABC Collections, when ABC Collections comes after me for that $100, they are acting as a debt collector. The FDCPA was enacted to eradicate unfair, deceptive, abusive, harassing trade practices within the debt collection community. Reason being is because debt collection companies historically are incentivized by how much money they collect for their original creditors. Differently, the original creditors are direct to consumer. They want to maintain their relationship with the consumer so that they will do further business with them, whereas the debt collection companies historically want to maintain their relationship with the original creditors by collecting as much money as they can from the consumer. So the federal legislature enacted the FDCPA. It is one of the statutes that constitutes the foundation of consumer protection law in the United States today. How do you know if you as a consumer have a Fair Debt Collection Practices Act claim or FDCPA claim? There's a lot of limitations that the FDCPA lays out for debt collectors. And it's extremely important for a collector to have adequate policies and procedures in place to prevent these violations. You as a consumer will know when your rights are being violated. And what do I mean by that? If you're being called 100 times a day, that's a violation, it's harassing. If somebody is calling your family, your job, your school, your friends to try to collect a debt, that's a violation. It's wrong. If you have an attorney that you've hired to help negotiate your debts and they're still harassing you and sending you correspondence, that's a violation. The FDCPA is actually it's a very comprehensive statute. It's very strict, but very comprehensive in that anything that a consumer would feel is harassing behavior on behalf of a debt collector, it addresses in some way, shape, or form. The FDCPA also provides for statutory damages in the amount of $1,000 per action, up to $1,000 per action. What's nice also is that even though this is a very low or relatively low damage amount for the consumer, it also provides for actual damages. So if they've actually injured you by collecting, maybe they've injured your credit or they've caused some severe emotional distress. And the statute also provides for an award of attorney's fees for the suing consumer. The defense for a debt collection company would be a bona fide error, meaning if the debt collection company can show that they had A, B, C, D, E in place and that A, B, C, D, E are followed 99% of the time and this slipped through the cracks, that's their defense to an action. And in most cases, if you could truly show that your policies and procedures are in place, the collector I mean, then they can prevail in a lawsuit. But what's nice for the consumer is that even if the debt collection company prevails in the lawsuit, in most cases, unless it was a bad faith lawsuit by the consumer will not be liable for the debt collection company's fees. What else do you need to know about the FDCPA? In Florida, we have an additional statute that mimics or expands on the FDCPA. It is the Florida Consumer Collection Practices Act. It's extremely important, especially for businesses and organizations in the state of Florida, to be aware of this. And it's very valuable for consumers to be aware of as well, to know their rights and to know if their rights have been violated. The main distinction between the FDCPA and the FCCPA is what I spoke about earlier. The FDCPA regulates debt collectors. The FCCPA regulates any individual or corporation trying to collect a consumer debt. Consumer debt meaning anything used for household, family, or individual purposes. Now, remember when I talked about that credit card company who's trying to collect their $100? The FCCPA applies to them. It applies the same or similar regulations and restrictions to any company who is seeking to collect a debt, whether it be a car finance company, credit card company, hospital, etc., etc. They have to follow the FCCPA. It also provides for a cap on $1,000 statutory damages, actual damages, and attorney's fees for the suing consumer. If the consumer loses, the only way the company or the defendant would get their attorney's fees paid for would be if the consumer brought the lawsuit in bad faith. Importantly too, there is a bona fide error defense in the FCCPA, meaning again, companies should be very cognizant of their policies and procedures when it comes to the collection of consumer debts, and make sure that they have A, B, C, D, E in place for what happens when a consumer is delinquent or when they're responsible and they need to be sent an invoice or a bill.